today, like I mentioned, we're going to talk about ethics and law. And so in terms of the exam itself, about 15% of the exam covers these two areas. So if you want to do quick math, it's roughly about half ethics and half communication law, the 15%, if you split it up. What you should do is review the specific knowledge, skills, and abilities as described in the study guide that cover this section. So you should do that. And then just to recap, the resources to support this section in your APR study guide, which hopefully you've all downloaded by now. The communication law ethics section is pages 101 through 106. I also suggested you might want to take a look at the AP style book, the briefing on media law section. In particular, the two sections on privacy and copyright are really good in the media law section to give you more background on those two areas. And then in the Cutlet book, the Effective Public Relations book, in the 11th edition, it's chapters 5 and 6 cover ethics and law. And so those are your additional resources to help you out in terms of this particular section. And so I divide it up into the two different groups. I want to talk about, first, we're going to talk about ethics, and then we're going to actually talk about legal issues that affect public relations from a communication perspective. So we're going to start with the ethics side of the of this particular session. So let's start with how do you define ethics? So think about each of you on your own. Think about how do you define actual ethics if somebody were to ask you that question. And if you want to just pop a quick answer into the chat, and we'll have Anne-Marie just share a couple of those. So a simple definition of ethics.
I don't see anything in the chat. I'm sorry, Em.
There's nothing coming up in chat? Are people?
Oh, there we go. There we go.
Oh, there we go. Oh, okay.
Got it. Yep. Practicing with honesty and integrity with public and your organization in mind.
Okay.
Maintaining moral and legal concepts. Moral principles that govern how you behave.
Oh, good. All right. Excellent. Excellent. All the responses there. If you ask people that question, you will get a myriad of responses to defining ethics. And so for most people, though, what we look at is that basically ethics is how we decide what is right and wrong. And all of you that responded actually captured that in some way, shape, or form, right? It's a decision-making process that is often based on our values, which are established from the time we're very young. And that's how we all have a specific process to determine what's right and what's wrong, and how are we going to act as a result of that. So it's kind of our moral compass is what we usually will say, most of us, is that it's our moral compass to help us do what is right and what is wrong. And so you might want to ask yourself, how do you determine when are you potentially in an ethical quandary? Are you is the situation you're facing an ethical dilemma? And a couple of things that I always like to share is, I know for me personally, and maybe you have a different response, but whenever I have to question whether or not I'm in an ethical dilemma of some sort, I kind of get a weird feeling in my stomach that's kind of telling me that maybe something isn't quite right here. And the minute that I have to question whether or not it's ethical, more than likely means it probably isn't. According to what I perceive as right and wrong, and the systems that I use and the processes I use to determine that. And so you each have your own way that you can identify how you feel when all of a sudden you are faced with an ethical dilemma. What is right or what is wrong? We have some processes here in PR. We actually have a decision-making model we're going to look at that will help us make an ethical decision based on circumstances we face in the profession. But a couple of things we might want to think about in terms of ethics and law, because these two are so often heavily intertwined. And so a couple of things to think about as we move along. And when we look at this ethical decision-making model, we'll actually have to ask the question at some point, is the action that we're examining, is it legal, first of all? And then where does ethics come into play as well? So we can think about, can an action or a decision be legal, but potentially unethical? And then conversely, can an action or decision be ethical? Maybe it's the right thing to do, but it's actually illegal that it is occurring or going to occur. And so if we look at these two different situations and apply them to certain scenarios, we can start to see how they play out. So for example, from a PR perspective, if you look at, can an action or decision be legal, but potentially unethical? Is it right or wrong based on perhaps what people, our publics may view or think? That if we take a look at, and you can pick whatever industry you want to, but if you look at potentially like the cosmetic industry, and within the cosmetic industry, when they produce different types of cosmetics, according to the FDA, they have to meet certain standards in terms of types of chemicals and products that can be put in cosmetics. So there is a legal threshold, a legal standard they have to meet. And companies meet that, or else, of course, they get fined. But the question may be, from an ethical perspective, if you can legally put in an ingredient that you know is a known carcinogen, is that ethical, or should you pull that carcinogen out? So for example, parabens are known to be carcinogenic, and there you find them in a lot of cosmetics, shampoo, etc. And so a lot of companies will actually stake their ethical reputation, being ethical companies, on saying we've removed all of those cancer-causing agents. All right, so they met the legal threshold, but they actually went one step higher. And from an ethical perspective, they pulled out ingredients that they actually could leave in ethically, but they have determined it's unethical to do that. And so legal, yes, what they're doing is legal. They could do it legally, but they've decided it's unethical and they're pulling them out. And that's how they're running their business. And you can track this across all industries, the food industry in terms of additives and GMOs, and industries that cause various types of pollution. They can meet the legal threshold, but maybe they go higher than that. And we see, if we examine social responsibility, concept of social responsibility in our industry, this is where we see a lot of companies do what's right legally, but they actually go beyond that and they do what they believe is ethical. All right. So then conversely, when you look at, can an action or decision be ethical, but possibly illegal? How would that potentially come into play? And so I love this example. It's some people say it's a PR example potentially from a law enforcement perspective, but it wasn't meant as a PR strategy or tactic. And so there was an incident, maybe some of you have seen this, read this article. It was a few months back, and it was on one of the East Coast, one of the cities on the East Coast. And a woman was arrested for shoplifting. She had young children. They were out of food. And so she actually was at a grocery store and she was shoplifting. She stole food and she was caught. Officer was called by the store to, in theory, arrest her. All right. I think we all would agree what she was doing was illegal. She was stealing food. And we agree as a society, there are laws against stealing stuff that doesn't belong to us, that what she did was illegal. The question is, would it be ethical? What would be gained by arresting this young mother and putting her in jail when she has young children at home to take care of? And so the police officer made the decision, instead of arresting her, he actually bought her groceries. And then he drove her home. And so her action was illegal. And in theory, the responsibility of the police officer was to arrest her because she had stolen merchandise. But he made the ethical decision that the right thing to do was to purchase her groceries and drive her home. All right, so that's where we start to think about this intersection of what's legal and ethical and what's illegal and what's unethical and how it can potentially come into play. So different situations, there are a lot of them. Probably you have some that you could share. And they're always interesting from a PR perspective to think about. All right, so I'm going to start out. We're going to give you a little example from an ethical perspective here. All right, so you work for a PR agency and you've been hired by a for-profit organization that has been receiving significant public pressure to change its name because many people believe the name of the organization is racist. So your agency recommends and the client agrees that you will establish a website and a social media campaign to position the current name as popular with significant support. So the communication campaign will appear to be a grassroots effort. Your agency is going to be invisible in the background, but you're controlling it. And it's going to appear to be a grassroots effort by individuals that support this organization in the name. All right, would you consider this to be ethical? That the agency has produced this campaign and is going to launch this campaign on the part of its client?
No.
So you might also want to ask, is it legal that they do this first? And so the question would be, is it legal? And then potentially, is it ethical? So see, so I heard one no and a very adamant no. Anybody else want to weigh in? These situations are always kind of gray. They're not real clear cut. Nobody else wants to weigh in? You probably know there's some kind of catch to this, so you're not going to say anything. All right, so this is actually what happened, excuse me, with the Washington Redskins, who of course this year we're no longer, or in 2020, we're no longer the Washington Redskins. So I don't know if we have any Redskins fans out there or not, but the Washington Redskins in 2014 were facing intense scrutiny and were in the media a lot because there was a case that was on its way to the Supreme Court about polling the name as being racist. Dan Snyder, who owns the Washington Redskins, had said repeatedly he would go to his grave before he would change the name. He wasn't going to do it because it was very popular and the fans supported it. And so in the midst of all this litigation going on and high visibility in the media and controversy around the name, in 2014, the Washington Redskins hired Burstyn Marsteller out of Washington, D.C. to create a campaign to actually drive support for keeping the name. And Burstyn Marsteller put together a very comprehensive social media campaign, an internet-based campaign, to promote the name of the Redskins and to say it was all fans that were behind this campaign. And it ran for months and months before it was, somebody outed it, and I don't even know how it was outed, that this was actually an entire PR campaign and that Burstyn Marsteller was behind it. And so if you thought it was unethical to do this, it has happened. Agencies do come up with these kind of campaigns and make them look like they're organic and grassroots. And the question is it deceptive to the public, to your audiences? So it probably wasn't illegal. They could do it. You know, I don't think anybody would say it was illegal. The question is, was it ethical? And how does that influence our industry in particular if we launch these kind of campaigns? All right, so something to think about because these things happen frequently.
Hey Pam, this is Ryan Dumas. I have a question for you.
Yeah.
I guess more of a comment. I guess when organizations do that, it's how stupid is the end user, you know, for us, you know, we know all what's going on in society. You know, the Redskins weren't the only ones that had all this political pressure. There's a lot of other sports teams that also had that same pressure, and other organizations that have different pressures, and, you know, all revolved around, you know, what was going on in the times. So it's kind of, I think, for someone to turn their eye to say, well, they weren't pressured into it. This is just, you know, fan support. I mean,
yeah,
I think you would have to be silly to not believe that, you know, there is political pressure to do it. I imagine there was a good bit of people who wanted them to keep it the Redskins. For me, it's always the Washington Redskins. It is not the Washington football team. I'll call them the Redskins to the day I die, just because it's what I grew up knowing them as. But I think, you know, from the practicing standpoint, it's silly to kind of turn your head to say, they won't know the difference because of what's going on.
And I guess the question is, that's an excellent points there, Ryan. And the question is, always, and this is where ethics come into play and the debate occurs, and it occurs in our meetings, in our offices, when we talk about campaigns like this. The question is, would the fans, loyal fans, have cared even, whether
True.
it was a grassroots effort or it was actually a PR firm behind it because of the information that they were sharing? Would they really care about who was actually sharing the information? So, but it kind of comes down to, we all have to assess ethically what we believe is right or wrong. And then if we work for organizations and organizations are having to make these ethical decisions, we have to be supportive of the decisions the organizations are making as well. They have to fall in line with what we believe as well. And so the Redskins case is really interesting. They actually lost their trademark, which if we have time, we'll touch briefly on trademark law at the end today. But they actually lost their trademark, the rights to their trademark, because it was found to be offensive in 2014, I believe, 2014 or 2015, the ruling came down. So they actually lost their trademark. And then, of course, at the beginning of 2020, end of 2019, beginning of 2020, whenever it actually occurred, the Redskins dropped the name due to immense corporate pressure to drop the name. And ironically, right now, they're still the Washington football team. And what we're hearing is the reason they haven't come out with a new name has to do with trademark law, that they're struggling to come up with a name that hasn't been trademarked and already, because if it has, then they have to buy the trademark if they can, which would be very, very expensive, or come up with a name that hasn't been trademarked. And there are individuals out there who have been buying up or who have been trademarking names that they suspected the Redskins would change to. And in order for the Redskins to use those names, they'd have to buy them from these individuals now. And it could cost, millions and millions of dollars. And so that's a speculation of why they don't have a new name yet, is it all has to do with trademark law. And so when you think about public relations, it really is interesting how legal aspects do come in and intersect with our industry in ways that we would never anticipate. And the Redskins is a really good case study to look at around that. All right, so let's move on here. So our challenge when it comes to ethics is really, how do we operate and protect the public interest and remain loyal to our employer? Because from a PR perspective, there's a belief that we're the interface between our organizations and the public. We're that intermediate go-to between the two. It's our responsibility to always operate in the public interest, but also maintain our loyalty to our employer. And I believe it was Ivy Ledbetter-Lee, who was one of the founders of modern day public relations back at the turn of the 20th century, who was very adamant. He was the first to say that in public relations that, we would not operate a secret press bureau. We were going to operate in the open in terms of transparency and honesty. And that's what we aspire to in public relations. Of course, we bump up against legal issues in terms of loyalty and protecting our employer as well, which we will look at a few of those as we go forward. But this is overall our challenge in PR. How do we operate really in the public interest? Public is in our name, public relations, but also remain loyal to the needs of our employers. So one thing you should look at definitely from a PRSA or FPRA perspective is both organizations, as all professional organizations do, have code of conducts that share our professional values. And you need to be aware of these, at least, at a surface level for the exam. So take a look at the PRSA code of conduct or the FPRA code of conduct. They mirror each other, and they focus really on these 6 concepts of advocacy, honesty, expertise, independence, loyalty, and fairness. And I'm going to go through these kind of quickly because we have a lot to cover today. We're really going to try to cover a lot of ground. But from an ethical perspective, this whole idea that we operate in the public interest on behalf of doing what's right for the greater good of the majority of the people. And so that's the first tenet of the code of conduct within our organizations, our professional organizations. That we should always be guided, obviously, by honesty and integrity, which is our ethical code, to do the right thing. and that we should always ensure that what we're sharing from an information perspective is accurate and truthful. We're not going to share false or misleading information. So as we all know in PR, one inaccurate story or sense of or perception that we are misleading the public can be very detrimental to our organization. Now, this doesn't mean that we have to share everything, because frequently from a legal perspective, there's information we can't share for our clients. And it's okay for us to say that. But our goal always is to be accurate and truthful in what we share. All right, that we're going to deal fairly with the public in terms of how we conduct ourselves, how we treat our colleagues, how we treat our organizations and our publics. And a good example of this is one of the things in terms, especially with our colleagues and the profession overall, and this can kind of be a challenge, is leaving proprietary information behind when you change jobs. I like to just touch on this briefly from an ethical perspective, because again, a legal aspect may come into play too. But the example I like to use is if you work for a nonprofit and you conduct a capital campaign, raise millions of dollars from high net worth individuals. You've conducted that capital campaign. You have the database of these individuals. You put in place the process in order to raise the money. All right, so the organization you did that on behalf of probably considers all that information proprietary, that they own all that information. Well, can you take that with you if you change jobs, go to work for another nonprofit that has specifically hired you to run a capital campaign because you did such a great job for the other organization? If you work in fundraising, you know this is very common. You move from organization to organization because of your ability to raise money, to fundraise. And so you have to ask yourself from an ethical perspective, what can you take with you? What do you have to leave behind? What is proprietary for the first organization? And then what can you take with you? You can't erase everything in your mind, because that's what an organization is hiring for you for, is your knowledge and your skill set. But you may have to, if you have a database, if you've actually created a database of high net worth individuals, you probably shouldn't take that with you. It should belong to the original nonprofit you created it for. That doesn't mean you can't create a new one, but from an ethical perspective, you shouldn't take the database with you. Now, legally, you may not be able to either. You may have signed a code of conduct, statement for the organizations in regards to property and what you create while you're there. And most organizations have code of conducts or ethical codes you have to sign. Frequently, you have to sign them every year so you understand the ethical perspective of the company. But something to think about, especially from a PR perspective and the type of work we do. What can we actually legally and ethically take with us when we go from job to job? So think about it. All right, a couple of other things in terms of our professional values that we focus on. We commit to advancing the profession through our expertise and constantly upgrading our knowledge through education, through accreditation, that we're always going to strive to have the latest information at our fingertips so that we really can provide strong counsel to our clients and our employers. All right, at the same time, we're going to try always, and this goes back to serving the public interest as well as our employers, we always want to be objective. And I would imagine if we could actually share stories about different situations in our various positions, we would see where probably most of us at some point in time have been the individual kind of saying the emperor has no clothes. We've had to be the voice in the room saying, hey, yes, you all want to go forward and do this, but we might want to think about it because the consequence could be X, Y, Z. And it's our responsibility generally as a PR person to be able to see all those sides, to see how it affects our organization as well as the publics we serve. Because ultimately, we're the ones that are going to have to communicate it. Whatever that decision is, what we're looking at, we're going to have to communicate it and we're going to have to defend it. And so so we have to kind of remain in that silo to be objective and independent and provide guidance. Doesn't mean they always listen to us. We've all been in that boat too, where we've provided what we believe is the best course of action and we've been overridden by management. Sometimes it works out, and sometimes we go into crisis mode. And as PR people, we're back. We're not going to say we told you so usually, except for in our minds. But we're usually dealing with a crisis then. All right, and so then lastly, and this kind of ties back to this whole idea of being independent and objective and serving the public interest, but ultimately, how do we remain loyal to our employers? And so this is a real challenge for us frequently. As PR people, we often have information we can't share from a legal or an ethical perspective, whether it's related to potentially layoffs, or maybe there's litigation of some sort against our company, and we legally can't share it. And so we have to determine how can we be open and honest with what we can share, but also understand we have to be loyal to our employers. And there are a lot of laws that help us now with that, like HIPAA, if you work in the healthcare industry. There's a lot we can't say because of HIPAA today. And so there are laws that help and protect us along that line, but it is a challenge for us because frequently we do have a lot of information that we can't share often for legal reasons, even though ethically, probably on a PR side, we would want to share them. All right, so let's jump into just a real quick scenario here. So let's say you're the director of public relations for a business that produces a well-known brand of food products. One of your products in Orlando has been found to have some contamination, and numerous individuals have developed severe intestinal problems. So the situation has been traced to your product. It's your product. Your CEO wants a recommendation to keep this situation from becoming a PR disaster. What would you recommend? Now, I realize you put together a whole full-blown crisis communication plan, but what would you actually recommend? Just very quickly, right off the top of your head, what's the first thing or second thing you would recommend they do? If you want to just drop a couple of things in, and we'll look at those real quick.
Pull the products, take them back. I think Tylenol did I said, pull the products down. I think Tylenol did was it Tylenol a couple of years ago?
Yeah, Tylenol did.
A while ago, right?
Yes. Mm-hmm. They pulled all the product. They're sort of the example from a crisis perspective on what to do in this type of situation. Yeah, and Tylenol, it's interesting, after all this time, Tylenol still comes up top of mind. And especially if you have a background in public relations, or you went to school for public relations or journalism. And and when we talk about crisis communication, I'm sure Tylenol will come up in that discussion as well. And there's an interestingly, and hopefully Rich Donnelly, he may touch on this, Johnson & Johnson produces Tylenol. And there's a sense that the strength of that brand as a result of how they handled that crisis back in the early 80s is still resonating with the company today, is protecting the company today, how strong that brand is. Because there's been kind of a resurgence, a little bit of discussion around with the Johnson & Johnson vaccine coming out now. It's interesting to see how people are bringing the strength of that situation back to bear with the Tylenol situation. So the one thing I wanted to mention, and Melissa and Lori, I think both commented on this from Tylenol perspective, is are you going to pull that product right away if you know for sure it's contaminated? First thing to do is pull the product. On the exam, it's very literal. And so we talked about that the exam is like a textbook exam from an academic perspective. So if you know a product is contaminated, the first thing you want to do is stop that production. You're not gonna issue a press release or hold a news conference, right? The first thing you want to do is stop the production of that product and or pull it from the shelves. So the exam is very, very literal from that perspective in terms of what should be the absolute first step on behalf of the company. All right, so think about that. I'm just going to zip through the decision-making process, because it's actually defined in your textbook and the study guide. And so there is a process to go through when you're making an ethical decision around. Obviously, first you have to identify it as being an issue, a potential issue or conflict. You want to identify all the factors that may influence your decision, both internally and externally. You're going to look at that. You're going to identify the key values, your personal values, and also the organization you work for. what are the key values of that organization that'll come into play with your decision making on the decision that you're facing. Of course, from a communication perspective, we're going to always look at who are the audiences who will be affected by our decision, and what is our obligation to them, whether they're employees or customers or clients or the community. What is our obligation to them, and how will they be affected by our decision that we make? Fifth step, we're going to look at what kind of principles are going to guide our decision making. So maybe we look at the PRSA code of conduct. We look at our business's code of conduct if we had them. That's going to help us make our decision. And then finally, we're going to make our decision, and we have to be able to support it. All right, as we go through that decision making tree from an ethical perspective. So there are steps we can go through. There is a model that can help us with our ethical decisions. Hold on one second, I have somebody in, there we go, okay. All right, so there are some additional resources to look at to help you. The PRSA Code of Ethics, the FPRA Code of Ethics. The PRSA website has an entire ethics section, and I believe I still think every month, every September is Ethics Month. And so there's a lot of visibility around ethics because it's such an important part of our industry. The Arthur Page Center has dedicated sections to ethics, and also the Page principles that were established by Arthur Page are listed on page 115 of your textbook, which is a good resource. The Institute for Public Relations Research has a lot of good information and research on ethics. And then in your textbook and in the study guide, there are various ethical exercises you could go through and look at as well, and practice from an ethical perspective. Because on your exam, the ethical questions will predominantly be a case study. That you will be a case study. They'll have some sort of scenario, and then you have to identify what's the proper step to take from an ethical perspective. All right, so we're going to move on.
Pam,
So
I had
that's
a quick
ethics. You can take
question.
an entire class in college on ethics, or there's all sorts of courses, but that was sort of speed ethics from a PR perspective, not
Hey,
too.
Pam, can I ask you a quick
important.
question?
Pam, you have a couple questions.
Yeah, go ahead.
So, for example, the Arthur Page principles versus PRSA Code of Ethics, since the exam is really literal and you said most of them will be more scenario based, do you see a situation where you have to know exactly how the principles are worded? Because, the word overall, they share the same message, Arthur Page principles versus what
Right.
PRSA Code of Ethics say. But do you have to know what exactly PRSA says or what Arthur Page principles are, or just a general knowledge of them?
You know what, Kelda, can you address that? Do you remember any of the ethics questions? Because Kelda's the most recent one. So my recollection is, because I took it quite a while ago, you had to be able to identify, like advocacy, honesty, loyalty. You had to be able to identify those. There was a question on identifying them. Because they all overlap, you should be able to pick them out, I would think, fairly easily. But Kelda may have a better, if Kelda's listening. Maybe we'll have to come back and ask Kelda that question. How specific you have to be. I would know the main tenets like we went through and what each of them means, and focus on that. Yeah. And then you're going to have the scenarios about what to do. If like I gave the scenario of, a tainted food product. What's the first thing you should do? Stop the production or pull the product from the shelf. That would be the answer. Or it may say, what are the first two things you should do? And maybe you need to stop the production, pull it, and then also immediately inform the public. Because some of the questions, there are 2 answers out of 4 or 5, and so you'd want to know those steps.
Hey Pam,
Okay.
I guess this is kind of, I don't know, it's not a testing question, but the situation of so you're in an ethical dilemma. I guess we all have. First off, we all have our standard morals and ethics. What we believe. And you have what PRSA and all these organizations say are ethical, and you should follow these principles. when you're faced with a situation, and we firmly believe, this is borderline, or this might fall in something that I would not normally do, I would consider ethical, but my CEO or boss or whomever says, well, this is what we're doing.
Mhm.
So then I guess you really have to draw the line to say, okay, I don't agree with this. To me, this is unethical. Do I stay on the train and do it anyway? Or do you then have to, I guess, decide to go somewhere else? You know, I guess that's the only really decision you could do or make. If you don't agree with it, to you, it's unethical personally. But if someone else is pushing it, I guess what it falls back to is it's a risk, because say, you know, the crap hits the fan, and then they always say, well, it's the head person that gets their head cut off. If something happens, they're responsible. But that's not always the case. Sometimes there is that trickle down effect to where it could come back to you, even though you didn't agree with it. You felt like it was unethical. You did it anyway because maybe you had to have the job, or you felt like, I have to do this. When push comes to shove, you may not be saved.
Absolutely. I don't know how others feel if they would agree with you, but I would agree with you, Ryan, on that. And most of us have been faced with that situation, or many of us at some point, or we will be faced with that situation where we will not agree, but we will be told to do it anyway. And we either, it goes against our own personal ethics, or we are sure it, you know, maybe we're going to cross the line into a legal issue, or it's definitely going to come back from a crisis perspective. So I'll just share a real quick example, and then we'll move on. If anybody else wants to share in the chat so others can read that, I mean, it's great to hear what other people have faced. I faced a situation where some people might say, oh, that it wasn't a huge ethical issue, but personally for me, it was. I worked for a company and we were announcing layoffs. And as with most organizations, if you've been involved in this, you know how this works. You know, you hit the press release, send it out, the news release at 5 p.m. You send it out at the end of the day because you really don't want to take a lot of calls from reporters. And so in this company I worked for, we were announcing layoffs. It was very controversial. There'd been a lot of buzz about it. You know, it was pretty commonly known that it was going to happen. We shipped the news release out at the end of day, and my boss, who was, I was the national PR director, and my boss was the vice president of public relations. He did not want to respond. He and I didn't see necessarily eye to eye on media relations in more than one situation, but in this particular situation, he told me specifically, he said, we're not responding. Now, for a PR person, that's hard to hear. He didn't come from PR. He actually had come in from HR. And so some of you can imagine my challenges. All right, so he said, we're not responding. I don't want to respond. And he said, you are not to respond to emails. You're to turn off your phone, your computer. You don't respond to emails. You don't respond to phone calls. You don't respond to text messages. We're not commenting. And you don't even respond if a reporter calls. Now, as the national PR director, a lot of my personal and professional reputation was based on my relationships with reporters. And so to be told, I was not supposed to respond, not even answer an email or answer a phone. Ethically, for me, that was a challenge, and it was wrong. And so I was caught in this quandary of, do I go against my boss and at least answer them and tell them we can't comment? Well, in PR, you know what that's going to do? You're going to end up in the newspaper saying, no, Pam Nolan, spokesperson for company X, said they're not going to comment on the layoffs. Well, that doesn't look good for your company. And so I was caught really between a rock and a hard place with that decision. And maybe some of you have faced some similar types of situations. My decision, that actually led to me leaving the company. That was kind of like the final straw for me, because ethically, I couldn't work in that environment. It was my professional reputation. Not only did I think it was the wrong response for the company, but ethically it affected me. So, yeah. And so it's interesting. Elizabeth is in the chat. I just happened to see it. I have another computer running the chat here, so I can kind of sort of see what's going on. That there is this constant tug of war between, and I was going to talk about it, and thank you, Elizabeth, for the nice segue into talking about legal issues. There is a natural tension between the legal department and public relations in particular. And if you know lawyers, if any of you know lawyers or spend a lot of time with them, their world evolves around risk. And this is kind of a general statement, but most lawyers are very low risk takers, and they tend to want to hold on to information. They don't want to share information. PR people tend to be the opposite. We want to share everything. We want to be open and honest and transparent. And so there's a natural tension between our two industries, our two professions. And some of you probably already encountered this in your work in probably more than one way. The best thing I can say is what has worked for me over the years from a legal perspective, and maybe some of you have tried this, and when we talk about managing relationships, and this is how you start to see the threads of what we do through our industry work together. When you talk about managing relationships, to me, lawyers are a key internal public for us, whether they're in-house or if we have, attorneys on retainer. Because we're a smaller organization, we don't have in-house lawyers. And so to me, lawyers were always a critical audience for me. And I always worked hard to build relationships with lawyers. I wanted to understand their world, and I wanted them to understand my world. And it didn't solve all of our conflict, but it certainly helped to understand where we both were coming from, both industries. Because ultimately, at the end of the day, we all wanted the same thing. We were protecting the reputation of our company, of our organization. They were trying to protect it from a legal perspective. We're trying to protect the reputation and build a very positive reputation amongst all of our key publics. So our end goal was the same between us. We just had very different, belief systems and ideas about how to protect the reputation. And it always helped, in my opinion, to build the relationships with those lawyers. And so if you have that opportunity, and again, we may talk about it a little bit more when we talk about managing relationships down the road, they should be an internal audience for you to think about and to build relationships with, especially if you have an ongoing interaction with them. Like if you work for a company and everything you ship out the door, every news release, social media post, et cetera, has to be approved by legal, you might want to get to know those lawyers. You might want to build a relationship with them. All right. So thank you, Elizabeth, for that transition and talking about moving into how we deal with managing, predominantly internal audiences around decision making. And so there's this whole body of public relations law, which some people, their eyes kind of glaze over when they talk about legal issues. I happen to find it fascinating. I think in our industry, it's becoming more and more important because of the digital world we live in. And case law, which is what drives decisions in the judicial world, is constantly evolving in the digital world still. And so I think it's very important for us to have at least a basic understanding of the primary types of legal issues that could affect us or that do affect us in public relations. And so I love this quote that the application that, what is public relations law? It's really the application of business law, polished with the veneer of First Amendment protection. Because that's what we're really talking about, is how do we protect our businesses or our organizations from a legal perspective. And it's rooted in the First Amendment. Most of the laws we're going to talk about today, the concepts are all rooted in the First Amendment. And so I'm sure everybody is familiar with the First Amendment in terms of covering free speech and freedom of the press, right to assemble, and the right to petition the government for redress of grievances. So we are, and there's, unless you've been, hiding under a rock, the First Amendment has been, front and foremost in discussions in the media and online for months and months now, in terms of various aspects of interpreting the First Amendment. All right, so just to briefly talk about First Amendment protection in terms of speech and where does public relations fall within this. There are basically what we call three buckets and types of speech. So we talk about from a First Amendment, and this is a First Amendment protection, what kind of speech is actually protected. And so the most highly protected type of speech, of course, is political speech and religious expression. And of course, this goes back to the founding of our country and having the right to actually speak out against your government and actually practice religion that may not be aligned with the religion that is sanctioned by the government. And so it goes back to the roots of our country, and political speech is highly, highly protected. And of course, we see that on a regular basis. as well as religious expression. Recently, we've added this concept of corporate speech, and most of this has arisen, especially since 2010. And this, if you're familiar with the Citizens United case that went before the Supreme Court, which basically, very simplistically said that corporations were basically entitled to the same rights as individuals when it came specifically to political speech. And so corporations and businesses have a right to speak out and share opinions and their thoughts around political issues and around social issues. And so we call that, kind of this idea of corporate speech today, and that it's protected. And we see this more and more, of course, organizations, businesses getting involved in political issues and social issues, and what level of information that they share and how they share it is protected under the First Amendment. So we have this idea of corporate speech, which is we tend to work under that umbrella in public relations. Then the second bucket of types of speech is this idea of speech that has some protection under the First Amendment. And that is commercial speech, which also comes into play in terms of public relations. And this is really on the side of buying and selling goods. So this is going to be our advertising, promotional paid post, all that. Commercial speech has to do with business and selling of goods and services. And of course, there is some aspects of that that are protected. And of course, there's some things you can't do along that line. And then this whole idea of what isn't protected by the First Amendment. Defamation, if we actually say something that is not true about someone, and we cannot legally defame individuals. And we're going to talk about that from a PR perspective. What does that mean? Defamation law. False advertising, misleading advertising, there's no protection on that. And then, of course, there's no protection around obscenity and the publication of certain types of what's considered obscene material. All right, so we fall actually a little bit in all three of these categories, and it's a good idea for us to understand how the First Amendment comes into play. And so we're going to look at, and this is what you'll be covered on the exam from a communication law perspective. We're going to look at this concept of defamation. And within defamation, we talk about libel and slander. We're going to talk about privacy, and we're going to talk about copyright law. Hopefully we'll have time, and briefly touch on trademark law. And then we're not going to talk about commercial speech and truth in advertising. That's one thing I'm not going to touch on. Advertising is covered under the Federal Trade Commission, and it's touched on briefly in your textbook and in the study guide. And there's, obviously certain aspects of advertising that we get involved in public relations, but a lot of us don't get involved in advertising at all on the PR side. That's all handled by marketing. And so, I'm not going to touch on that today. If you have any questions, I can do my best to answer them for you, but we're not going to actually touch on that. All right, so let's start with defamation. All right, and we're going to I'll talk a little bit about defamation is basically the sharing information that damages somebody's reputation. And this is key to defamation. It has to be false. It can't be true, what you say. And it actually has to hurt somebody's reputation. They have to be able to demonstrate their reputation has been damaged because of what you said that wasn't true. All right. There are two types of defamation, libel and slander. We tend to hear pretty much, it's generally just referred to as libel. Libel is either written or in picture form, graphic form, but libel also covers, so we think of newspapers, magazines, blogs, etc., in a written format, but it also, libel covers the broadcasting industry as well. So when we talk about somebody maybe in a news story on television, if they sue for defamation, it's referred to as libel because of the reach of the broadcasting industry. Slander traditionally is considered, spoken or verbal. You say something negative about somebody that's not true, that potentially could damage their reputation. And so we really tend to focus, usually the kind of the catch-all word these days is libel, or we just talk about defamation overall. All right, but that's the primary difference between the two. Slander is spoken or verbal. It's often in a smaller setting, maybe one-on-one or small group is where you hear it. Otherwise, you move beyond that, and we're talking usually using the term libel. All right, a couple of things to be aware of when it comes to defamation is how people are considered in terms of defamation, because it makes a difference. So in 1964, there's a seminal lawsuit that was decided by the Supreme Court, the New York Times versus Sullivan. And this is the seminal decision, seminal case, court case that identified that if somebody is a public figure, then they are voluntarily putting themselves out in front of the public, and they're choosing to be in the public. And so if they believe they have been defamed, they actually have a higher standard of burden to prove that the reputation has been damaged. And so they actually have to prove, public figures have to be able to prove that there was actually actual malice. It was intentional of the person who they believe defamed them, that they did it deliberately. And they did it with malice, to really harm that individual's reputation. And so the basis of this is this whole concept that public figures, public officials voluntarily choose to operate in the public eye. And so they are opening themselves up to more scrutiny. And so it's going to be more difficult for them to be able to prove that their reputation has been damaged. So they have to actually, there's this burden called actual malice for them in terms of being able to win a defamation suit. It's a much higher standard. And so we look at, versus a private citizen. And so we need to think about, when we talk about defamation, the first thing we talk about is who's a public official, who's a public figure, because when we think about public officials, they're usually serving in some sort of government or quasi-government organization. Public figures are going to be your celebrities, the people who choose, actors, singers, our public figures are people who choose to operate in the public sphere. And actually much of their reputation is a result of their actions in operating in the public sphere. And then who is a private citizen as well. And so we have these three different categories that we look at. For defamation to occur for a private citizen, the burden is much lower. And so they look at, would a reasonable person think that what was said was harmed their reputation? So you don't have to prove actual malice. It was intentional. For a private citizen, it just is, would a reasonable person say that, oh, well, they shouldn't have said that about that person because it's hurt their reputation, and maybe their spouse left them, their business, went under, and so they were damaged. Their reputation was truly damaged by what was said. All right, so these two different levels of burden in a defamation case. All right, so when we look at defamation or slander or libel, whichever you'd like to call it, there are 5 elements that have to be present. So the first is this idea of defamation. There actually something had to be said that was not truthful about the information, about the individual. So first of all, we have to prove that something was said or published that actually was negative or untrue. You have to be able to actually identify the individual. I mean, you have to be able to say, if I believe a newspaper article came out about me and I was defamed in it, I have to be identified. And so have to be, you have to have that something untrue was said. The person has to clearly be identified, had to be communicated somehow, either published or broadcast. And then you look at this whole idea of fault, and that's that burden of proof. Was it, if it was a public figure, was it actual malice? Was it intentional that whoever said this or wrote this deliberately did it to harm this individual? Or was it really just negligence that a reasonable person would just say, they didn't really mean to do it, but it happened. All right, and that's for private citizens. And then the other aspect of that, of course, is, was the person's reputation damaged? Was there actually some sort of injury or damage to this individual as a result of what was published or said? So you have to have these 5 elements actually for libel to even occur. And if you don't have all 5, then you're not going to have a case to go forward. All right, so those 5. Obviously, on the flip side, your defenses, if somebody sues you for defamation, of course, what you can say is, no, that what we published was true. I mean, truth is obviously a defense. And then there's these 2 concepts of privilege and fair comment. And privilege goes to the heart of if somebody, public meetings and public forums, that you can actually repeat what is said and shared in those open public forums. All right, that's privileged information. You're in a public setting. You should expect that people are going to share what you said. Fair comment is aligned with privilege. Fair comment gives us the opportunity to comment on what is said in public settings, public forums, public meetings, and then also offer our opinion. And so if you write letters to the editor or opinion columns and potentially repeat something that may be perceived as damaging towards somebody, I mean, we're commenting from an editorial perspective, and that's protected. You are protected under the fair comment defense for libel. And then, of course, the other aspect, and this really comes in from a newspaper perspective, is if you actually retract a story, and hopefully as quickly as possible. All right, so those are the 4 defenses if somebody actually sues you or your organization for defamation. All right, and I actually just talked about these, so you have them written down as well: the truth, the privilege, and fair comment. All right. All right, so a couple of things from defamation to think about. And we can run into problems with defamation in public relations in terms of what we share, possibly in different types of material that we're printing. We have to be really careful, and it kind of crosses into privacy as well. And so we'll point out a couple of those going forward. But a couple of things to think about is from a defamation perspective, which is always interesting, is can dead people, which is always controversial, especially with high profile individuals, can dead people be defamed? And then also, can companies be defamed or organizations be defamed? And so can an organization sue an individual or a media outlet for defamation? So a couple of things to think about from a defamation perspective. So we can come back and you can pop those into the chat and share with each other. And then we can, if we have time, we can come back and talk about both of those. But I'm running out of time because there's so much to cover in this section. So I'm going to kind of move right into privacy and then copyright law. All right, so the other law, we looked at defamation, and we're going to look at privacy. And so privacy law really comes into play a lot for PR people in terms of what we're publishing in particular these days. And so privacy falls back again under constitutional protection, that we all have a right to be left alone. There's a sense that we should have safe space, places we can go, like our home, and what we do there is private, and that we will be left alone overall. And so there's this whole concept of privacy that we hold near and dear to our hearts in terms of US citizens. It's becoming harder and harder, this whole sense of privacy, because of, quite frankly, all of us carrying cameras in our pockets these days. It's becoming much harder. And the proliferation of information, of course, through social media. All right, so a couple of things when we talk about privacy and how it's different from defamation. You can sue for intrusion of privacy, or you can sue for defamation. The difference is privacy frequently, when we talk about privacy, does not affect our reputation. So, and we'll look at different types of privacy laws, and you'll see how that works out. So defamation will damage our reputation, will actually cause harm to us. Privacy, when we violate somebody's privacy, frequently does not damage somebody's reputation. That usually doesn't happen. They're just upset because it's private information, private activities that we do not feel should be shared. All right, so that's how the two differ in terms of reputation. So if we look at a couple of ways to protect ourselves from that, one of the things we want to do from a PR perspective is we always want to secure permission from individuals. So if you're responsible for newsletters or blog posts or website content, if you're profiling employees, you always want to get, or customers or clients, you want to get permission, preferably in writing, lawyers would tell you, preferably in writing, that will protect you and your company if you're going to be sharing information about an individual. Especially if it's highly sensitive, if you're dealing with somebody who's maybe fighting some sort of illness or has personal challenges around, maybe their spouse lost their job and, so they've signed up for support through food banks, and you want to highlight that and how your company is supporting the food banks, which directly helps your employees. You want to make sure that you always have their permission to use this information so that they don't come back and say, you invaded my privacy, you had no right to that. All right, and so that's why we talk about, and maybe some of you have this as an order of business, hopefully within your organization, where you get written permission, either specifically through waivers or for for news stories, website, however you're going to use that person's information, write it out specifically and don't go beyond what's in that agreement, where you're going to use that person's information. And so make sure you have that, unless some businesses will right up front will have in their employment agreements that they can use your likeness in advertising or promotional materials. It may be in the employment agreement that you sign as part of working in a company that they have access to use certain likenesses, images, your title, whatever they put in there. And so you want to make sure whatever organization you're working for, what's in place to protect the privacy of individuals you may be using in your content in some way, shape, or form as part of your promotion. All right, because you want to protect their privacy and make sure that you don't inadvertently result in one of these damages in terms of privacy, because this is what we look at in terms of privacy law. And you think about your work and what you do in PR and how some of this might happen. There's 4 kinds of what they call privacy torts, or how can we actually invade somebody else's privacy. One is appropriation, so using somebody's name or likeness without their permission. And so if you are running a Facebook post for your company and you see somebody's photo on another Facebook post, and you want to grab that photo of that individual because they're like perfect for your company, and you plop it into a Facebook post for yours to promote your company, you just appropriated, you've taken somebody else's image and are using it to promote your company without permission. And so you want to be really careful on the appropriation, making sure we don't use people's images without their explicit permission for what we're using it for. Intrusion is when we actually go into a space, an actual physical space, that there is a perception that we should have privacy. So going into our home and shooting photos of people. Maybe we get invited into somebody's home to interview them and take a couple of photos of them. But at the same time, if we see that they have all sorts of really cool stuff around the rest of their house, we take photos of that and we run those in the story we're running about this employee, but we don't have permission for photographing all that other stuff and sharing it, then they could come back and say, hey, you invaded my privacy. You only had permission to take pictures of me, and specifically what we were talking about, nothing else in my home. And so intrusion is when we go into that space where people they believe they have privacy. So we want to be careful about that. And then public disclosure of embarrassing private facts. This happens a lot with celebrities. If they do sue for privacy violations, they sue because of information has been shared. We see this on with celebrities with photos a lot. It's not if they, had, nude photos taken 10 years ago and somebody got hold of them and they published them on the internet. So they don't go after them for defamation, whoever published that. They go after them for invasion of privacy, because their reputation necessarily, more than likely, has not been harmed because of the photos being published. All right, so that would be the difference. If it could be defamation if their reputation was harmed by the publishing of these photos. However, more than likely their reputation isn't harmed. And so they go after for invasion of privacy, saying those photos were private and there was no right actually to share it. They were on somebody's, phone, and they were supposed to be, or in the cloud. And we believe that they were in a private space, and now we've shared them. And so, so we have to be careful in terms of what we actually say and what could be perceived as being embarrassing as well. And then the fourth tort of privacy is casting somebody in a false light. And so a good example of this would be if you're running a story, say you're printing a newsletter, and your organization has made a donation to the American Cancer Society, and you have this wonderful photo of an employee that you just adore, who's, employee of the month or whatever. And so you put this employee's photo adjacent to the story on the fact that you're supporting and donating money to the American Cancer Society. The perception from readers may be this individual has cancer, but the individual doesn't have cancer. And so you've actually just cast this individual potentially in a false light. And so we have to be really careful in terms of how we link information together. All right, so those are what we call the four torts of privacy in terms of privacy law that we need to be aware of. And again, the waivers and permission are your best friend. You want to always have permission to share information from your employees, your clients, your customers, whoever they are. Real quickly, I'll give you one example of privacy. Maybe some of you heard about this a few years ago. I believe it was in 2017. There was a woman who sued Chipotle for $2.2 billion because a photographer had taken her photo in 2006 and at a Chipotle in Denver, Colorado. The photographer asked for permission to use her photo and sell it to Chipotle, and she said no, and she never signed a waiver. And then she realized in 2015, she saw her photo in Chipotle ads in a number of Chipotle restaurants. And so she actually went back and sued them for invasion of privacy, that she, that her privacy had been, invaded. She was eating lunch and she never gave them permission. She thought she was, in a safe space and nobody was going to be taking her picture and making money off of it. So she sued them for what the company made between 2006 and 2015. All right, and they ended up settling out of court. But here's an interesting situation that arose throughout this. At first, people felt really bad for this woman. There was a lot of discussion around how Chipotle had appropriated her image. They'd stolen her image to use it without her permission. And then the story came out, of course, and they pulled this from legal filings that she sued, the woman who sued Chipotle. She didn't have a job. She hadn't worked for years. She had less than $100 to her name, no house, no car. And so this started to get reported in the media about who she was. And of course, all of a sudden, kind of the pendulum swung. Public opinion was, she was just going after a big company looking for money. And so it wasn't Chipotle that published the information. It was reporters who pulled it from the legal findings. All right. She ended up settling out of court with Chipotle for an undisclosed sum. So, but that's how, when you look at how privacy can come into play, is, this woman had every right to say Chipotle appropriated her image, and they used it to make money. They used it without her permission, and they made a lot of money off of it. Now, Chipotle could argue really did that one image that was posted in restaurants really significantly affect their business. That, of course, would more than likely be the argument from a legal perspective. But to make it go away, of course, they settled out of court with her. All right, so privacy, something we have to think about. So one, it's interesting, from a privacy perspective, one of the questions that has come up in the past when I've conducted a couple of these sessions in the past was about posting images of people online. And so if you're, how can all these viral videos be out there of people who are harassing people in parks and, for whatever reason, and there are a lot of them out there, and people are posting them. How come the people in the videos don't sue whoever posted the picture or the video of them for defamation or for invasion of privacy? And so, one of the things we have to be aware of as individuals, there's a difference when we're in the public sphere. So when we're out in public, we really don't have a reasonable expectation of privacy. And it didn't matter. It didn't matter before we all carried cameras in our pockets because people weren't snapping pictures right and left. Today, we all have a camera. And so if we're out in the public in any way, shape, or form, people can take our picture or shoot a video of us and post it out on the internet. And we're going to have a hard time saying that that our privacy was violated, that we've been defamed by it because we're out in the public sphere and we basically surrendered our reasonable expectation of privacy. And so something just for us to think about where we are in terms of what we're taking pictures of, how we're taking them, where we're placing them. Now that's an example where it may be legally okay to shoot video of somebody, out at a park and post it on the internet, or take pictures of people out in public and post them on your social media page. Legally, it may be allowed, but you have to ask yourself, ethically, is it the right thing to do? Just because we can do it, should we do it? Are we trying to humiliate somebody by posting their video? I mean, we're not necessarily being malicious. We're just not being smart and probably, good citizens around that. But we see that all the time. And I know the question always comes up, well, how can people shoot these videos of these people in parks and post them and not, be sued for defamation or invasion of privacy? And, and it all boils down to the setting of, in those situations, the settings. Where did it occur? Have we given up our right to privacy because we're in that sphere? Whether it's right or wrong, that's an ethical question that we should be doing that. And we all have to answer that question all the time. I personally go nuts when I see anybody who has posted a picture, especially of children, on their social media posts that they've taken out in public. It makes me absolutely nuts because I don't think we should be taking pictures of other people's kids and posting them on social media. All right.
Hey, Pam, isn't there like the guidelines though? I'll use I don't know if you're familiar with this show, Impractical Jokers. Have you ever heard of that?
Practical Jokers? Mm-mm.
Yeah, it's called Impractical Jokers. It's like a true TV show, whatever, but it's a group of, it's a group of people who go out and they've been lifelong friends. They go out and kind of do all these crazy pranks and stuff, whatever, and they involve other people unknowingly. And then, obviously they record it and they air it on TV, but how they get by of showing all the faces and whatnot is, after they do the pranks and whatnot, because they do some crazy stuff. They get signatures, obviously from the people saying, yes, you can do it. And so sometimes, they'll be showing this prank and there's someone who is beside them or whatever, or maybe had their face blurred out. So that's someone who obviously didn't get permission. Right. But I guess the question is like, how do they get by with it when they have, say if you were working for this like production company and you're doing it, but you have someone that's kind of in the background a little bit, you can't really clearly see their face, but you could, if you knew the person, you would know like, oh, that's Jenny, that's Sally or whatnot. How do they get by with a lot of this stuff? Do they go by? They're like, well, you really can't tell who it is unless you really know them. So therefore it's ethical to do that and to show them, or no, you have to blur their faces out and follow all these things, or because you could be sued. I can't speak to that from a movie production perspective. Somebody who works in that industry would have to say how they do that. Maybe they have all the extras or whatever, sign waivers right up front, if you're called to be an extra. Right,
I
okay.
know in the newspaper industry is, and if you go out and read the Society of Professional Journalists, if you read their code of conduct and you look at how they approach, especially photography, is that it's a question of, are you singling out the person? Who are you singling out
Okay.
to highlight and identify? And is the individual identifiable? You know, that's what you're doing. So yeah, you're in a crowd, there may be a crowd shot, but the question is the person who's identified. Are you really zeroing in on one person? And that person, you better have permission
Okay.
from. You want to have permission from that one person. If there are people in the background, and so, you know, generally speaking, they're not identifiable in terms of, and you're not talking about that individual, then you are protected. At least from a journalism perspective, that's how we, you know, journalists approach it when you're taking photos. It's a matter of who are you focusing on in that
Okay.
photo, in that shot. Because yes, you may have people in the background that are kind of blurry. From a motion picture perspective, that I don't know how they do that. But and depending on where it's shot, I mean, if you're like shooting a documentary and you're out in public, you know, you're out at a park or something, you may be focused on, you know, whoever you've hired, and maybe you're focused on that person, but there are people wandering around, you know, in the park behind. Well, they're in, you know, a public space. And so you kind of gave up your expectation of privacy. So I don't know if that answers your question, Ryan. I'm not really sure.
No, I just had a curiosity. I was just curious because I always, you know, my experience is the attorneys always say, no, you need to get everyone to sign something.
Yeah.
You know,
well, and
like,
that's why, you know, from a protection perspective, the attorney's not wrong. I mean, they're right. You want to protect yourself as much as possible because you don't want somebody coming back and suing your company and, you know, trying to lay claim to, you know, money or whatever. And so it always err on the side of getting waivers and having people sign and give you permission to shoot that, you know, to shoot pictures of them, video of them, whatever it is, and identify where it's going to be used. I know in companies I've worked for in the past, we always had employees sign waivers every time we had them in front of a camera, whether we were doing photos, whether we were shooting video, and they were part of that. We even went one step further and we paid them. And we actually compensated them. It was ridiculous. We would give them like, you know, $100. But we actually compensated them as well. And so that, you know, we felt like our attorneys felt like that completely protected us, because not only did we have their permission, we actually compensated them for the work they did for us as well. And so, but at a minimum, you should have, you know, waivers that have been approved by a legal department to sign to protect you. All right, so great question. Thank you. All right, so we're running out of time, everybody, and I apologize because there's always so much to get through in this section. Talking about copyright law, how do you guys feel? I mean, I can go like another 10, 15 minutes if you're okay. If you have to duck off, I understand. I will make my slide deck. I'll email it to you. I think I can email it to everybody, the size of it. I'll try to email it to you. You know, I'll make it available to you if you find that helpful. I would be happy to do that. Or answer questions, you know, next week going forward, or you can contact me at any time as well. Do you want me to keep going? Did everybody feel okay for just another few minutes? We'll
Do you want to unshare your screen just so you can see the chat as well?
I actually can see it. I have a second computer running.
Okay, okay.
Well, I kind of sometimes look over and see it. So if you have any questions, so is it all right for, if you can hang in there, we'll hang in there for a few more minutes. If you have to duck off, I certainly understand. All right, copyright law, I'll just hit the high points of this real quick. Copyright law is definitely an area we should be aware of in public relations because we publish a lot of information. You know, it's kind of the depth and breadth of a lot of what we do. I love to use this photo real quick. I'll just share it. Some of you may be remembering it because it sort of sums up a lot of copyright law. This was at the 2014 Oscars. Ellen DeGeneres there in the center was the host that year. Maybe some of you are too young to remember this, or maybe you saw the photo, but hopefully almost everybody saw it. And so if you remember, well, you probably don't remember that year. That year, Samsung was the major sponsor. Ellen DeGeneres had a Samsung phone in her hand, and she was wandering around throughout the whole event, taking pictures, and then they were posting them. All right, so So at one point, Ellen DeGeneres was in the audience. All these celebrities, gathered around, who they are there. She actually handed the phone to Bradley Cooper in the front. Bradley Cooper took the photo of them. He took this selfie of all of them, or groupie, whatever you want to call it. All right, Bradley Cooper took it with the Samsung phone from the sponsor, and Ellen DeGeneres was the host. All right, so the question would be, who owns the copyright on this photo? Who owns the rights to this photo based on all that background information for this one little photo, which at the time was the most highly viewed photo on social media. Got millions and millions and millions of shares. Anybody want to venture a guess real quick? Think about who owns the rights to it.
I could be totally wrong, but it seems like it would be Bradley Cooper because he was the photographer. And when I use photographers' photos, I need to give them credit, but not sure.
You are absolutely right.
Yay!
Bradley Cooper, because he is the originator. He's the artist. So whoever creates, takes some sort of artistic creative element, puts it in tangible form, the creator automatically at that point owns the copyright to it. So Bradley Cooper took the photo. So legally, he would be the owner of that photo. Now, the difference that came into play here, and this is heavily disputed, and you can go out and research it yourself. I've seen stories on both sides. I don't think we'll ever know the true story. Samsung claims they staged the whole thing, and that this was, a $1 million PR coup for them. There is huge question that this was staged, because if you actually saw the clip, how it all came together, you had a whole lot of people you had to get together at the right time to get them all there to take the photo. And so, then if indeed it was staged, we'll say this, if indeed it was staged, and if indeed Samsung, told Ellen DeGeneres, get this photo with our phone, in the contract, it would have to be spelled out specifically, Bradley Cooper would take the photo, but Samsung owns the rights. So you have to ask yourself from a legal perspective, do you really think Samsung went that deep into planning this photo and making sure it went off without a hitch, that it would be in a contract to the point specifying Samsung would own it, not Bradley Cooper? Because that's the only way Samsung could own it, is if it was actually in a contract that it would be their photo, not Bradley Cooper's, because he actually originated it. So at the end of the day, so something to think about copyright law in terms of who owns the rights. That's what it all comes down to, is who owns the right and has the right to use copyrighted material. So Bradley Cooper, if you think about it kind of in the big picture, Bradley Cooper and Ellen DeGeneres, they're not going to make money off of this. They don't care. This is just good visibility for them because they're celebrities. Samsung used it in advertising campaigns and promoted this photo and made money off of this photo. And so an interesting question, they may have secured the rights afterwards, whether or not they actually had the rights to it. And Bradley Cooper, and just said, I don't care. Ellen DeGeneres was out of it at this point. But Samsung ultimately made money off of it. And you can go do your research and you'll find articles saying both, that it was just spontaneous and was not planned. And then you'll see articles that Samsung took responsibility for it being, like the PR coup of 2014. So it's kind of an interesting situation, but it's a fun photo and a good way to look at who actually owns the copyright on an image or a piece of content. All right. So copyright law, as we look at it, the courts, copyright law is covered by is a federal law, and it's fairly draconian in the sense that it is what it is. There's very little flexibility in copyright law. All right, so the courts impose, they look at in terms of what is copyrighted material. All right, and so it has to be original. It has to be creative. All right, so that means you used your mind, required some sort of intellectual labor, and it has to be novel. It has to be very different from what currently exists. All right, so that's how we start to determine whether or not something can be copyrighted. All right, ultimately though, copyright, you have all these three-part tests. Ultimately, it becomes eligible to be copyrighted when it actually becomes tangible. So even if Samsung, say to our Samsung situation, even if they created this idea, we're going to make this selfie happen with Bradley Cooper and Ellen DeGeneres and all that, they couldn't copyright the idea. You can't copyright the idea. You can't copyright any kind of content until it's actually tangible. It has to be physical. We have to be able to touch it. All right, touch it and see it. And so that's when it becomes copyrightable. And so there are two types of copyright. We look at copyrights, what can be copyrighted from two perspectives. We look at common law copyright and statutory copyright. And common law copyright says the minute that creative expression, that original piece of work becomes tangible, the creator, the originator, owns the copyright right then and there, and they own the copyright to that work. And so, and then there's the time period that they own the copyright to the work as well. All right, so a few things that can be copyrighted. We think about any kind of literary work, music, including actually the sounds, the lyrics, etc., plays, dramatic works, pictures, sculptures, everything really what we think about on the artistic realm, including architecture, can also be copyrighted. A few things that can't be copyrighted: ideas can't be copyrighted, facts can't be copyrighted, everyday processes can't be copyrighted, theories on history can't be copyrighted, anything that the US government produces cannot be copyrighted, and then anything that's already in the public domain cannot be copyrighted. And so there are various elements we look at in terms of what is copyrighted versus what isn't. All right, and so, but we have these two kinds. So you have whatever you've created. So let's say you're gonna go out and launch your own website. And so the minute you create your website, you own the copyright to that website. It's just automatic, it's tangible, it's your website, you own it. Maybe put the little C, mark on it if you want to tell the world that you own the copyright on it. It's your work. All right, so that's one type, common law copyright, automatic. Everybody has it the minute that the work is tangible. There's a second type of statutory, called statutory copyright, and this is where we actually register our copyright with the Library of Congress. That's the entity, the public entity, governmental entity that oversees copyright. And so when we register with our copyright with the Library of Congress, that is called statutory copyright. And the actual copyright symbol, it's very important that it is on the very first copy of what you have distributed or what you have sold, because that's going to identify that you actually were the original creator. You put that copyright symbol on at the very beginning. All right, so the question always comes up, do you have to register copyrighted material with the Library of Congress? And the answer is no, because as a creator, the originator, you own the copyright at the time you create it. The benefit to registering it, so it becomes a statutory copyright, is if you are concerned that somebody may ever infringe upon your copyright, trying to use your work, because then you would sue them for copyright infringement. And if it's actually registered, you have a much stronger case, because it's much easier to prove you were the originator, you're the owner of the copyright. And so you want to look at these two levels of copyright protection. So, common law, when you create it, you have limited protection. Statutory copyright, you register it with the Library of Congress. That gives you a much higher legal level of protection as well. So two different levels of copyright for you to think about. All right, there are a few opportunities for us to use copyrighted material without having to pay for it. And those are usually, we look at fair use and the type of organization, like for teaching, educational purposes, you can use certain amounts of copyrighted material. We can use some on the editorial side. We can, the courts will look at how much under fair use, how much of a piece of material you use. Do you use a couple sentences out of a complete, 400-page book, or do you use 2 chapters out of a book? All right, so fair use is one aspect of copyright law that allows us to use some aspect of copyrighted materials without infringing on the owner's copyright. All right, so because of the primary basis of copyright law is to protect what we create, and so that other people don't profit off what we create. If there's going to be profit made, we're going to make it. Our organization, us as individuals, we want to own the copyright, so we make the money off of it, not somebody else. All right, so something from a copyright perspective. So these are the factors when we look at fair use, which I was just mentioning. We look at the purpose. What is it going to be used for? Is it used for educational purposes? What actually was the type of copyrighted work that is being looked at? Was it an entire novel? Was it a song? Was it a melody of a song? And so what might be able to be shared and what might not be able to be shared under fair use, depending on the type of copyrighted work. How much of that work is actually used? And then ultimately what they're looking at, the courts look at, is have you diluted the value to the owner of the copyright in terms of their ability to make money? Have we impacted the market value of copyrighted work and the owner? So those are really the 4 points that if you think somebody has infringed upon your copyright, the courts are going to look at to determine whether or not there actually has been copyright infringement, are these 4 different aspects. And one thing I would just mention, because I think it's relevant in public relations, parodies fall under the fair use doctrine, because we frequently on campaigns will parody something that has been copyrighted, whether it's a book or a play, or maybe a song. We'll create a parody of something in pop culture that our audience will resonate with our audiences. And parodies are covered under the fair use doctrine, so we don't get sued. And so probably most of us, or some of us at some point, have had some sort of parody that we've used of copyrighted work within our organization. And that's how we get away with it. That's how we can use it, is parodies fall under fair use as well. The only person who doesn't probably get away with parodies is Weird Al Yankovic, if you're aware of who he is. He does parodies of pop culture songs all the time, and that's how he makes his living. And I have no doubt he pays for the right to do that to the original artist, because he makes a lot of money off those parodies. Those of us in our work, we don't. We're using it to promote other events, activities, information, etc. All right. So a couple of things just to think about copyright infringement and whether or not you may be protected under fair use. If you have to question how much you're using or what you're using, you ought to be cautious about that and maybe consult an attorney. And it is very difficult to determine fair use. It is definitely a challenge with copyright law if you are in the courts to determine whether or not what has been used is really a valid use, or have you truly infringed upon somebody's copyright, because the law historically has taken a pretty dim view on infringing on somebody's copyright to protect people. And we want people to be creators and originators, and copyright is one way to encourage that and protect people. So something to think about. All right, so here just real quick, and a couple of questions. So think about, do you have to use a copyright symbol on your original creative work to protect your copyright? So do you have to put the copyright symbol on your original creative work to protect it? So that's a question. I'm going to give you the answer. The answer is no. You don't have to put the symbol on there, because the law says the minute you create that it's tangible, you own that copyright. The challenge is if you put the copyright symbol on it, you're telling the world that this is my work, I copyrighted it, all right? I own the copyright on it. You're telling the world that. If you go to the next step and register it with the Library of Congress and get that statutory copyright, you have that even escalated, that higher level of protection should somebody infringe on your copyright and you want to sue them, because you have to be able in copyright law go back and prove you were the originator, you own that original copyright. And so there are those 3 layers. You can produce something and own the copyright on it. You can take a photo. You can go outside your office today, take a photo. You own the copyright on that photo you just took. All right. You could choose to put a copyright symbol on it, let the world know. Or you could if you wanted to, register it with the Library of Congress to protect it if you thought it was going to be $1 million photo. All right. So there's 3 different layers. All right. Here's a question for you. Let's say, and I don't remember who mentioned this. Somebody mentioned this in the chat. If you hire a freelance photographer to shoot photos at a fundraiser you're coordinating for the nonprofit where you work, who owns the copyright on the photos shot during the event? So you've hired a freelancer. Who owns the copyright on those photos? All right.
You're paying for them, even though the photographer is the one who's taking them, which would originally fall like the photographer. But because you're paying for them, wouldn't you become the owner of them because they're handing over the rights to you?
All right, so good question. We have a little bit of controversy in terms of, does the photographer own them or does the person who hired the photographer own them? Because you're paying for them. So the answer is, if you go back and think about the originator, copyright, a product or a creative expression becomes copyrighted at the time of creation. The originator owns the copyright. And so the photographer would own the copyright to those photos. And a lot of PR people, I know a number of people who've gotten caught on this. They've hired freelance photographers to shoot, whatever they need to shoot, whether it's a fundraiser or they have them coming in. I used to work for a developer, and we'd hire photographers to come in and shoot, $1 million penthouses and such. And the photographers own the rights to all the photos because they're the ones creating that tangible artistic expression. And so the only way the company would own it is if we contractually agreed to that up front. And so you would sign a contract with that photographer that the photographer gives up the rights to the photo and assigns them to your organization, and then you own the rights. Very few professional photographers ever give up the rights to their photos. They want to own them. And what they often will do is give the company that hired them limited use of the photos. And so in a contract, it will say you can use these photos, during 2020 in promotional, ads in various magazines or whatever you define. And so it's actually spelled out. But it's very rare for professional photographers to give up the rights, the ownership of those photos. They want to retain them. So you always want to be really careful if you're hiring freelancers, whether it's photographers, writers, web developers. You need to know who owns the copyright on that content that is being created. All right, so this kind of falls in line with that. The same as the question, if you hire a graphic artist, or here, let's say you're an employee, we'll do it both ways. You're employed by a large corporation as a graphic artist. So who owns the copyright on a new logo and artwork you create to launch a PR campaign? So you're an employee now, not a freelancer. You're an employee. Who owns what you create at work? So Melissa's hot this afternoon, and yes, so she said the employer owns it. If you are an actual employee, everything you create, if you're an actual paid employee of an organization, everything you create belongs to that company. And so the company would own the logo, the artwork, everything you create. If you're an employee, you're taking photographs, the company owns it. They own the rights to everything because you are an actual paid employee. This is what you're being paid to do. And so the organization owns all the rights. The difference comes in if you are I'm going to skip over that real quick. If you are working with freelancers and you're not an employee. And this falls under what comes in, and this will probably be a question, depending on which version of the exam you get, this whole idea of works for hire, something to understand around content ownership is, and copyright in particular, this whole idea of works for hire. Who owns content that is created? And so if you are a freelancer or you're working with freelancers, the originator, the freelancer, will own photos, website content, blog posts, anything they create for you, they will own the rights to that unless you specifically say in a contract with them that they're assigning the rights to you and you will be the owner, your company. Something to be aware of. Conversely, again, if you are an actual employee and you're performing work on behalf of your organization, then the organization owns the rights to everything you create. And so we really need to be careful when we work with freelancers or independent consultants or solo practitioners in our work, or if we are on the other side and we're doing freelance work and we want to protect our own work, we need to make sure we understand the contracts that are in place, the agreements we put in place as to who actually owns what we're creating. And this is something when we're busy in our PR work, we don't always think about. We just hire a graphic artist, say, hey, create this logo for us. And we don't specify who owns it. And if we don't, we could have a graphic artist owning the logo to our company or our organization. So something to be aware of. This whole works for hire doctrine and who owns content we're developing.
What happens when you have a project, if you're working like a collaborative project with a designer and, they're coming up with a, template shell, but they come up with the solid framework for design, whether it's graphical or even if it's writing, they come up with a framework for the story or whatnot. Then you take it and then you're kind of evolving it. Do they still, because it was a freelancer, is that kind of what it has to be spelled out? Or if it's not spelled out, does that mean the freelancer still owns that copyright to that piece, or how does that work?
Again, I'm not a lawyer and I'm not offering legal advice,
right.
But I would go back at this stage to what copyright law actually says. And so if it is a creative expression and it becomes tangible, in that the originator would potentially own it. Because if you think about it, they could take that template, they could take that architecture and sell it to multiple clients. And then are you comfortable with that other people have a website that looks like yours, other than maybe the actual, stories, images may be different, but they're incredibly similar. So the question would be, in your contractual obligation with the graphic artist or the web designer, what is spelled out? Who owns what? It's always safer. I'm married to an attorney and my son's an attorney, and they're big on getting everything in writing, down to the little bitty details. Who owns what? So you don't run into a litigation issue down the road. You want to be aware of that. So, for example, we work with for our business, we have a website. We work with a graphic artist who actually developed it for us, our website. But we fill in content here and there. She does some, but then we put in content, I manage, some of the content on a day-to-day basis. And her actual contract with her clients specifically says she owns everything she develops. And so most people never read that. And probably most of our clients don't realize they don't own their websites. And so, but of course, being married to an attorney, I read the contract, and we actually went in and negotiated with her and said, we want to own our website. We don't want you to have any ownership over it whatsoever. And she agreed to modify her contract so that we actually have the ownership of the website. She doesn't. And, but that's very common. They want to protect their work too. So, and there's a lot of questions around it, especially now there's so much going on in the digital world and information is being shared so quickly and rapidly. And they're really valid questions you should ask your attorney. That's why, kind of circling back to protect our organizations, it really is a good idea for us to have really good relationships with attorneys if we have them on retainer with our company. And if you're working for an organization and you feel you have any risk at all in terms of ownership, you should hire an attorney or ask an attorney to protect yourself. You're never going to go wrong. Does that sort of answer your question, Ryan? Yeah. Okay, so something to think about. So it can be a really gray area who owns what, but you get into the courts, and the courts, it's not so gray. They're going to go right back to who actually created that and is the originator of it in terms of copyright. All right. One thing I'll take just real quick on trademark law and how it mirrors or how it relates to copyright law, because sometimes there's a question. So copyright law is the art, the tangible expression of an artistic, a creative type of work. And so we can actually copyright images, copyright work, plus also as organizations own a trademark on them. And so, because a trademark law, under trademark law, it can be a name, a word, a phrase, a symbol, which identifies a product or a provider. So this is on the business side. This is business law. All right. And we notify, we can register similar to copyright law, where we can just put, a copyright symbol on our work and not register it. We can do that with trademark law. And you'll see this with different companies. If a logo has a TM after it, it means the company is putting you on notice that this is trademark. They create it, they're claiming it, but they haven't registered it. And so on trademarks are registered through the US Patent and Trademark Office. And if you actually register your trademark, that's when you put the R symbol on it. That's where trademarks that have actually been registered have the R for registered symbol. And if it says TM, it means the organization is claiming a trademark, but it hasn't been registered. So that's the difference between the two. A couple of things. So like for Nike has trademarked the name, the swoosh, and the phrase, just do it, the slogan. Those are all three different trademarks for Nike. Disney, of course, owns the copyright on Mickey Mouse, the original artwork of Steamboat Willie back in the 30s. They own the copyright, which was when Walt Disney, drew him and put him in tangible form for the first time. They owe the copyright on him. And then, of course, they're trademarked as well. Mickey Mouse is also trademarked by Disney. The difference between the two from a legal perspective, a primary difference is copyright law has an ultimate limitation on it. Copyright law is governed, the whole idea, the law was set up that at some point everything goes into the public domain where everybody can use it. So copyright law, as of I believe it was 1978, said that a copyright can be retained for the life of the originator plus 70 years. So after the originator dies, whoever created that copyrighted work, 70 years after that, it would go into the public domain and anybody could use it. Trademark law is different in that trademark law, you have to renew your trademark every 5 years. If you don't, and it can go on forever though, it doesn't end. But if you don't renew your trademark, if it's registered, then you can lose it and the name becomes generic and anybody can use it. So for example, at one point, the name Band-Aids was actually, it was a registered trademark for a company. Well, they lost their trademark, it became generic, and now everybody can call any kind of, Band-Aid Band-Aids, which some of us do. But there's actually a trademark, a company that, that actually produces Band-Aids. So you have to be careful with your trademark, but it can last forever. So one of the challenges that Disney is facing, if you're a Disney fanatic, of course, being in Orlando, so many of us are, is that Steamboat Willie, the copyright on Steamboat Willie is set to expire in 2023. And so the question is, what will happen when Steamboat Willie enters the public domain and anybody can use it? And there's kind of a sense that Disney will be able to protect it under trademark law, that they'll be able, because they also protect the Mickey Mouse image under trademark law, that they'll be able to protect it and keep control of it in terms of their branding and imaging through trademark law, even though they will lose the copyright to Steamboat Willie. So already, I'm sure there are Disney lawyers working on it. They're used to dealing with this. They fight with trademark issues all the time in terms of using Mickey Mouse. But it will be interesting to see what happens when it enters the public domain. Okay, so quick difference between trademark law and then also copyright law. And so very quickly today, we covered a lot of ground, and all I could do is, reinforce. I'll share my slide deck. I'm happy to do that. Cover the readings in our textbook as well. It's 15% of the exam, so don't go flipping out too much over it. Roughly 7.5% on ethics and 7.5% or so on law. But even beyond the exam itself, is there really good ideas and information for us as everyday public relations practitioners to be aware of the ethical and legal ramifications that affect our industry. And so hopefully on top of your exam and moving on to the next step, becoming an APR, you'll be a little bit more aware and maybe dig a little bit deeper into some of these issues that are affecting our industry, because they're going to continue to escalate as we, grow ever deeper and deeper into this digital, immersive, digital world as well. All right, so, my final thought always is lawyers can be our best friends. This is my husband and my granddaughter, of course. But I mean it sincerely that it really is a good idea for us to seek out attorneys and really help them understand our business, and then for us to also understand their business so that we can ultimately work together to benefit our organizations and protect the reputation of our organizations. And so with that, I'm going to apologize because I went way over. I'm so sorry about the time. So much information. We got to figure out how to cut this section down a little bit. But I'd be happy to entertain any questions if anybody wants to stay on and throw some questions out, or just email me. We can help out. Anne-Marie, Kelda, and I are here to help you. And I very much look forward to next week. And I thank you for your attention today. Next week, we start the race or the RPI sections. We're going to do 2 sessions back to back because it's so important on the research, planning, and implementation and evaluation of campaigns in the public relation world. And so look forward to seeing everybody next Wednesday. And thank you so much for your time today. Take care.